Good morning. I'm Aidan O'Connor. As the chiefs have said, I'm the president of the Association of Criminal Defense Lawyers of New Jersey. And I'd like to thank the chief, the justices of the Supreme Court, and Judge Grant for calling this judicial conference and giving me the opportunity to speak to you here today. And Judge, I did look at this. It's 9.5 minutes, so I'll work on that. I come to this conference with a somewhat unique background in that I was a federal prosecutor for 18 years and have been a defense lawyer for the past 13 years. And I've also worked on civil litigation cases both before and after I was a prosecutor for a total of about 17 years. I note first that the ACDL joins in and fully supports the excellent interim report submitted by the New Jersey State Bar Association, and I can recommend to you all that you read it in its entirety. There seems to be little dispute on some issues, and we fully join in with the long overdue proposals to make the veneer pool more representative, including expanding the list used to choose the panels, increasing the compensation to allow more people to serve, including payment for transportation, and perhaps providing childcare at the courthouse, and the loosening of restrictions on who can serve as a juror. These changes will do more to make for a fairer, more representative pool than anything else that is being discussed at this commission. We further support the use of the objective test by the trial court in ruling on Batson type challenges and for de novo appellate review. Having been the subject of a Batson challenge while a prosecutor, I can tell you that it does feel like one has been accused of being a racist. And judges naturally do not like to make that finding against lawyers they see before them every day, who they consider to be decent people. Changing the standard will allow that decision to be less charged and thus fairer to the participants of the trial and more likely to uncover implicit bias in jury selection. We also support the proposal by the Office of the Public Defender for greater involvement by attorneys in the voir dire process, as we believe that it too will lead to fairer, more representative juries without unnecessarily increasing the time spent picking the jury. And we further support the data collection on jurors and veneer panels as set forth in DANXO. The ACDL and NJ, and to my knowledge, almost all of the bar associations in the state categorically and strongly oppose any reduction in the number of peremptory challenges, and especially to those granted to defendants in criminal cases. Peremptory challenges are the last escape valve to let the parties to the trial, through their attorneys, have a direct way to ensure that the jury will be fair to them and thus leads to greater respect to the outcome. Trial judges have subtle and not so subtle pressures put on them to pick juries as expeditiously and efficiently as possible. They have administrative judges, clerks' offices, and logistical problems to deal with, to say nothing of their calendar. We talk of implicit bias, but pretend that these institutional pressures on the judges do not exist. Given that the jury pool is unrepresentative at the start, and that the judiciary's own study shows that peremptories are not a systemic cause of bias, and at worst have played an attenuated role, one wonders why the issue of peremptory challenges has been so strongly pushed at this conference, and even in the decision in Andahar itself, which did not involve peremptory challenges, except for the denial of a request for an extra challenge by the defense after the rather explicit bias by the state in its for-cause challenge and arrest of the potential juror. Indeed, it often seems that the judiciary's push to limit the role of attorneys and the number of peremptory challenges is a solution in search of a problem. The judiciary tried to limit peremptories a decade and a half ago with a different set of supposed problems, and has consistently tried to reduce or eliminate challenges in the name of efficiency every year since then in various committees. These attempts have consistently been opposed by the trial bar, by those people who are responsible for trying cases, for representing their clients in individual cases. Why? I submit to you that trial lawyers, to say nothing of their clients, of defendants who face years in jail, have a very different position in the judicial system and in the criminal justice system than do judges. We all want justice. But we as lawyers, and especially as criminal defense lawyers, have the primary responsibility for protecting the rights of our clients. of the all too often indigent minority defendants caught up in the criminal justice system. And it is our collective experience that defendants cannot rely solely on the often flawed system of challenges for cause to make sure they get a representative jury. It is the lawyers in consultation with their clients who truly understand the case, who have lived with it far longer and far more intimately than any trial judge. It is those lawyers who are best attuned as to who will be a fair juror. This commission recognizes that implicit bias exists and that it exists in potential jurors. I submit to you that it is the trial attorney who is in the best position to determine if a potential juror may harbor implicit or other biases against the defendant. There is no evidence that lawyers are abusing this discretion on a systemic scale. And I submit that if lawyers do attempt to abuse it, trial judges are well situated to stop it. If only they will actually uphold properly made Batson challenges rather than attempting to rehabilitate veneer persons or justify improper strikes. And that would be more likely to happen if the objective test is adopted by the Supreme Court. Instead, as the State Bar Report notes, too often do trial lawyers hear, well, you can use a peremptory challenge instead of sustaining the Batson challenge. So where does that leave us? All of the relevant bar associations, criminal lawyers, defense lawyers, prosecutors, civil lawyers, whether on the plaintiff defense side, oppose eliminating peremptory challenges. The judiciary's own study shows that peremptory challenges are not a systemic source of racism. What's left? A very old canard, court efficiency, which is now spun into an unsupported claim that veneer persons somehow feel bad when they don't get chosen to sit on a jury. I wonder how that sits with our lived experience. But the statistics put forward do not tell the whole story. As reported by Mark Twain, there are lies, damn lies, and then there's statistics. Those phantom 10,000 jurors are not solely the result of unused peremptory strikes. The court should and can determine the approximate number of jurors they need for any trial. But to attribute unused jurors solely to unused peremptory strikes ignores that most people excused are excused for cause and because cases often settle or plead out on the day of trial. And presumably the courts know this when they decide how many people to call in to be on a jury panel. Indeed, it appears not even the judiciary thinks this is a problem for shorter trials. However, I suspect that the need for a larger veneer pool has more to do with people seeking to be excused due to the length of trial and financial hardships than the amount of peremptory challenges. I note that there has also been criticism of the amount of peremptory challenges based on the age of the statute authorizing them. I suggest to you that the right to a jury trial is also based on old law. And we could certainly be more efficient if we did away with the jury, but that is not the American system of justice. And a reduction of peremptory challenges is not consistent with the oft-stated precept that the New Jersey Constitution is more protective of defendants' rights than is the federal Constitution. In closing, I repeat that the ACDL strenuously objects to any reduction in the amount of peremptory challenges in jury selection, and I implore this commission to not sacrifice the defendant's right to a fair and representative jury, his ability to strike someone he believes may have an implicit or other bias against him or her on the altar of a false efficiency or an unproven assertion that they are being systematically abused, especially when the evidence that does exist shows that to the extent that Batson abuses happen, they are much more likely to be committed by the prosecution. Thank you for your attention and support of this critically important right of defendants and litigants, and we look forward to continuing to work with the commission in its important work. Thank you.